Students with Disabilities and Their Personal Data. Brought to you by AHEAD and Dawn, the Disability Advisors Working Network. This video was designed by College Disability and Access Officers to inform students with disabilities about how their personal data is processed in order for the college to provide supports. We live in a data-driven world. Almost every transaction and interaction you have with most organisations, including your college, involves you sharing personal data, such as your name, student number, address and date of birth. You share data online too, every time you visit a website, make a browser search, buy something online, use social media or send an email. Sharing data helps make life easier, more convenient and more connected. But your data belongs to you, so it's important that it's used in only ways you would reasonably expect, and that it's stored safely and securely. Data protection law, sometimes known as the GDPR, aims to make sure that everyone's data is used properly and legally. So, why do colleges need your personal data? Well, they will need to request your personal data to assess what type of reasonable accommodations, more commonly known as supports, should be made available for you. To assist them with the process of providing supports, they collect and process your personal data, such as your student ID number, your CAO and/or DARE application information, your course details, and the evidence of your disability. As well as for the provision of supports, they need to collect this information for funding bodies who require it to provide funding to cover the cost of supports and for other relevant correspondence and reports. Data protection law requires colleges to obtain the consent of each student in advance of processing their personal data. Your consent must be freely given for a stated purpose and must be informed and unambiguous. This means that before you consent, you must fully understand how they will use your personal data, for what purpose they will use it, and that they are fully transparent with you on how and why they will process it. It must be just as easy for you to withdraw your consent as it was to give it. By giving your consent, your college can work with you to ensure that any reasonable accommodations required by you are identified and provided. If you provide medical evidence regarding your disability, this information will not be disclosed to any third party, except where necessary to provide you with the reasonable accommodations that have been identified as necessary for you as part of the needs assessment process. If you request and are granted an exam accommodation like extra time in exams, the college will, in consultation with you, disclose relevant information to the exams office so that they can make the appropriate arrangements for you. Should your lecturer or tutor contact the disability office for advice, they will be informed that your consent is required before any personal information is given. It should be noted that you are perfectly within your rights to refuse to give your consent to your college disability or access service to process your personal data. However, in this scenario, colleges will be unable to arrange any reasonable accommodations that require disclosure of disability. So, what kind of personal data will a disability or access office share, and who shall they share it with? Well, firstly, they will never share any of your medical documentation or evidence of disability with anyone outside the service. That's a given. They will often have to share your name, student number, and course of study in the normal process of organising supports for you. In some cases, they will share basic information about the nature of your disability, where it was required, for example, to explain the reason for a reasonable accommodation, or provide information about how an accommodation should be delivered. Where information is shared, it will be minimised where possible and given on a strictly need-to-know basis. Examples of who might need to know in order to provide support are relevant university and college staff such as course lecturers, tutors or the examinations office. External employers or agencies if you are on a professional course and placement is an integral part of the course. In such cases, with your consent, your placement needs assessment report will be shared with the external body. Bodies offering relevant funding streams, such as the Higher Education Authority's Fund for Students with Disabilities. External support providers, for example, Irish Sign Language interpreters or personal assistants. The Residential Accommodation Service, where you apply to stay on campus on disability grounds. Counselling and/or health services during the referral process. Library services, for example if you need additional borrowing privileges due to your disability. estates and facilities if you need access to universal toilets, for example, and external professionals, where the Disability or Access Service will ask for your written permission to liaise with other named external professionals involved in your disability-related care and support. College Disability and Access Services take the responsibility to protect your personal data very seriously, and your information will be stored securely in either an electronic or hard copy format. For electronic formats, they will store your personal data securely on the university premises and use secure IT platforms within the European Economic Area that are also subject to European data protection requirements. Hard copy records will be stored in a secure location with access restricted to relevant personnel only. They will hold your personal data for approximately 7 years following your graduation or withdrawal, after which it will then be securely destroyed. It should be noted that there are some circumstances where colleges are allowed to process your data without your express consent. For example, in the case of an emergency, where a student is unwell or injured or at risk of injury to themselves or others, where it is necessary to protect the vital interests of any person, including the student themselves, if there are fitness to practice issues or a legal duty to report something to a professional body, such as the Teaching Council, if there is a complaint or an appeal to the institution, if there is a legal reason, for example a legal dispute or where required by a court of law, or for the prevention or detection of a crime, or the apprehension or prosecution of an offender where it might be shared with law enforcement agencies. Even after you have given consent to the college, the law ensures that you have a host of rights regarding your data. For starters, if you change your mind, you have the right to withdraw your consent for the college to process your data, where your consent is the legal basis for them processing it to begin with. You also have the right of access, which means you can request a copy of all the personal data the college is processing about you at any time. This process should be as easy for you as granting consent was in the first place, and the college has to respond in a reasonably timely manner. Additionally, you have the right to have any inaccuracies about you and the college's data records rectified, and the right to have the data the college is storing about you erased where there is no longer any justification for retaining it. Although there are some exemptions here, such as the use of pseudonymized data for scientific research. If you feel that the college is processing your data unfairly or disproportionately, or is processing data for direct marketing or marketing-related profiling purposes, you have the right to object to such processing. You are also entitled to restrict the processing of your personal data if, for example, you are in the process of contesting the accuracy of the data, if the personal data was processed unlawfully, if you need to prevent the erasure of personal data in order to comply with legal obligations, or if you have objected to the processing of the personal data and wish to restrict it until a legal basis for continued processing has been verified. Your other major right is to the portability of your data, meaning that you can have a readily accessible electronic copy of your personal data transferred or moved to another data controller at your request, if they are processing your data based on consent and if that processing is carried out by automated means. So, I know that was a lot to take in, but feel free to rewind and rewatch certain parts as necessary, and hopefully you now have a much clearer picture of how College Disability and Access Services use your data and what rights you have regarding how they process it. Thank you for watching. This video was brought to you by Ahead and Dawn, the Disability Advisors Working Network.